Hello, and if you're just joining us, I'm Claire Morell. I am leading up the Big Tech project at the Ethics and Public Policy Center, and we are going to kick off our second panel this morning, which is going to focus on antitrust law as it relates to Big Tech. And so I will go ahead and introduce our three distinguished panelists that we have joining us this morning to discuss antitrust law. So without further ado, let me introduce Roger Alford is our first panelist, and he is a professor at Notre Dame Law School. He joined the faculty there in January of 2012, and Professor Alford teaches and writes in a wide range of subject matter areas, including international trade, international arbitration, international antitrust, and comparative law. He also served as the Deputy Assistant Attorney General for International Affairs with the Antitrust Division of the U.S. Department of Justice from 2017 to 2019. And before entering the legal academy, he served as a law clerk to Judge James Buckley of the United States Court of Appeals for the DC Circuit and Judge Richard Allison of the Iran United States Claims Tribunal in The Hague, Netherlands. In addition to publishing widely and leading law reviews and journal, Professor Alford is the general editor of Kluwer Arbitration blog and on the executive committee of the Institute for Transnational Arbitration. And he earned his BA with honors from Baylor and his JD with honors from New York University. Our next panelist is Dr. Mark Jamieson, and he is the director and Gerald Gunter Professor of the Public Utility Research Center and director of the Digital Markets Initiative at the University of Florida. And he provides research and international training on business and government policy, focusing primarily on information technology, antitrust technology development and adoption and regulation. He's also currently a visiting scholar with the American Enterprise Institute. And prior to joining the University of Florida, Dr. Jamieson was a manager of regulatory policy at Sprint and head of research for the Iowa Utilities Board and a communications economist for the Kansas Corporation Commission. And he received his PhD in economics from the University of Florida and a Master of Science in Agricultural Economics from Kansas State University. And our third and final panelist this morning is John Newman, who's a professor at the University of Miami School of Law and an affiliate fellow with the Thurman Arnold Project at Yale, and a member of the advisory boards of the Institute for Consumer Antitrust Studies and the American Antitrust Institute. He also regularly consults with private sector clients on a variety of antitrust-related matters. And Professor Newman's research, which has appeared in the University of Pennsylvania Law Review, Vanderbilt Law Review, George Washington Law Review, and other leading journals, focuses primarily on antitrust issues involving digital markets. And he's credited with coining the term zero price markets. And his scholarship in zero price markets has been cited by regulators and legislative bodies around the world. And before joining academia, Professor Newman was also an honors program trial attorney in the U.S. Department of Justice Antitrust Division. And so without further ado, I would love to just ask if someone would like to just give a brief statement of what antitrust law is for those who are tuning in who might not be as steeped in antitrust law and its general kind of purpose. Why do we have antitrust law? Kind of what is it? If anyone wants to just volunteer to give a brief summary before I have some further questions about your opinions on how it relates to big tech.
I'll let one of the law professors take the lead on that.
Yeah, Professor Alford or Professor Newman, do you want to give us a brief summary?
John, do you want to do it or you want me to?
I'll let you at least start it off, and I'm sure you'll do an excellent job.
It's really straightforward in that it simply is the law that was developed to promote competitive markets. So there's a recognition that competitors should vigorously fight in the marketplace for market share and to enhance their market power. And yet there's a recognition that there's essentially three types of conduct that are potentially problematic in the world of antitrust. One, agreements between competitors, so various types of price fixing or market allocation agreements. Two, monopolistic behavior that is abusive or exclusionary. And then the third major category are mergers between competitors that lead to significantly high concentrations such that they are likely to harm competition. So generally speaking, the world of antitrust law focuses on one of three things: illegal mergers and acquisitions, price fixing or market allocation agreements between competitors, or abuse of monopoly practices.
That is a great summary. Thank you so much. So now I do want to ask each of you in turn to just share what you think the greatest challenges that big tech and maybe digital markets more generally pose to current antitrust laws, and why. So I don't know if we want to start with Professor Newman. Would you be willing to go first and just share what you think the challenges are that big tech and digital markets kind of pose to current antitrust law?
Sure, yeah, I'd be happy to take a crack at it. It's of course a big topic. It's the topic of the day, right?
It is. We'll unpack.
I'll pick a
things
few.
in order, but go ahead.
All right. So, I think at least one of the challenges that big tech firms, and we're speaking at a very high level of generality, of course, because a lot of these firms have really very different business models. The things we lump together under big tech, to an economist like Dr. Jameson might look actually very different. But speaking then at a very high level, I would say one of the biggest challenges that big tech firms and those business models and markets pose for antitrust regulators today is how do we pick which constituency within US society is the favored one from an antitrust lens? So for a long time, dating back at least to like 1979, consumers, right, were said to be the favored constituency from an antitrust lens. So we look at conduct through this lens of consumer welfare. And conduct is good if it leaves consumers better off. It's bad if it makes them worse off, basically. Mm-hmm. So then a big challenge that these businesses, a lot of them pose is, who are the consumers, right? So you take something like Facebook. I'd argue the primary consumers are advertisers. Facebook's business model is basically harvesting attention from us and then selling it to the ultimate consumers of attention. Now, those are advertisers. Now, Facebook also makes another product. It's not attention. It's like social media or something like that. And that's consumed by us. So right off the bat, you've got, two potential products floating around. You've got multiple groups of consumers. Their interests are not always aligned. Sometimes are directly opposed. And that poses a problem, even if we want to stick with this consumer welfare kind of paradigm, which is a little bit narrow relative to what things were historically. You've got a problem as an antitrust regulator. Who's the consumer? And we used to do things like just assume that, say, if output is going up, that's good for consumers, because if consumers are buying more, they must be happier. That gets harder when you have multiple products floating around, and the same conduct could push output of one up and output of another down. All of this just gets a lot messier, and it's not as obvious who the favored, constituency that we're supposed to be protecting is.
That's really helpful. Professor Alford, do you have thoughts building off of that on the challenges?
Claire, I think it's really important that you distinguish between the different types of companies. The concerns that are raised by some companies are very different than the concerns raised by others.
Right.
So take Amazon, for example. Probably the biggest concern about Amazon is that they are the platform for third-party marketplaces, third-party vendors that provide services and goods on the marketplace, and yet they also compete directly with those third-party vendors. And unlike other analogs in the brick and mortar world, they have just enormous data about how those third-party companies are doing, and they can see which ones are going viral and which ones are stagnant, and they can immediately decide when to compete and how to compete with those situations. So Amazon, probably the biggest concern is that they are a platform for third-party vendors, and they compete with those vendors on their own platform, and then they have the ability to use data in a way that is not traditional in other situations. So that's probably the biggest concern with respect to Amazon. With respect to things like Facebook, as we saw in the decision yesterday, it's a very unusual situation for monopolization, because normally monopolization is looking at monopoly pricing behavior. And at least as framed in the complaints by the FTC and the DOJ, the main concern was in so-called zero price markets, right? And the zero price markets are unusual, and because you don't normally look at quality degradation as the same metric as monopoly pricing behavior, even though you certainly could do that. But to show monopoly power in the Facebook model is going to be different, when you can't, at least on the consumer facing side, you can't show the traditional monopoly pricing behavior. You have to show other sorts of things. I think Google is a very complicated model. Full disclosure, I'm advising the state of Texas in their ad tech case. So there's a variety of different concerns with respect to Google. The DOJ case is primarily about search and search advertising, and the ability of Google to monopolize search advertising. The Texas case is primarily about the ad tech stack and the display advertising and web and advertisements that appear on websites or throughout the internet, and the pricing behavior and other sorts of behavior that happen with respect to publishers and advertisers. Apple is a whole nother category. I think the Epic Games is a concern about the App Store as a separate market, and they can charge monopoly pricing 30% for in-app purchases, as well as downloading apps. So there's essentially this argument similar to the Kodak case from many years ago, that there's a special market for apps on the in the Apple ecosystem, essentially. So it's really difficult to sort of say there's one major concern or one major issue. They're all very different. There are common themes, which is data is overwhelmingly significant with all of these types of companies. There is a network effect that happens with most of these companies, where essentially there's either a winner take all or winner take most scenario, where the network effects of having friends and colleagues and family members be part of the network creates a tilting effect. Or in the case of, say, app stores, all the app developers realize they have to have apps for Android and for the iPhone. So there's a network effect that happens. So there are many aspects, I think, that are different about this. And probably the biggest concern is simply the overwhelming amount of power that these companies have. That would be the overwhelming issue, I think, that unites Republicans and Democrats.
No, that's very helpful. And I think you're right in distinguishing the kind of, there's distinct issues, there might be common themes, but it's helpful for you to kind of clarify some of those distinct kind of issues related to big tech with antitrust. Dr. Jameson, I want you to have a turn to answer this question, and then I'll jump into my next question.
Sure, thank you very much. So I'll take a little bit different perspective on it. I don't think we have necessarily problems with the antitrust laws. It's more the mechanisms we use to try and to enforce them that I think we have challenges with now. It doesn't bother me that there are multiple customers groups for these companies. We've been through that before. We know how to either say these customers are more important than those, or to say they're all equal and simply add up how they're affected. And then the network effects aren't necessarily new to us either. We can look at those from multi-market perspective, or look at, just like I did with Microsoft, that this group of customers leverages what a company can do with another set. I think we can deal with all those. I think the two main challenges we have are how fast these markets move, and then also how all of these companies that people are worried about are actually managing ecosystems. And that is different for us. We've seen some of those things before, but this is different. The way that we try to enforce antitrust today is we first try to identify what is a market, and then we look to see if there is power in that market. Someone is able to behave without paying much attention to customers and rivals. Defining what that market is requires historical data. And you have to have a few years worth. But in today's world, by time you've gathered that data and analyzed it, markets have moved on. And so we don't have that historical system, that historical approach to be able to identify the markets and actually measure if there's power within them. And then with respect to the systems, what we see are that if Facebook has an ecosystem within which a lot of people operate. Google does as well, Amazon does as well, Apple does as well. So this is now companies managing systems. And so we have competition between the systems as opposed to necessarily competition between different products. The product competition still occurs, but it's the system that really matters. And historically, the way we've been able to view this over the years, you've probably heard of Metcalfe's law. We have Bell's law, which kind of works in the same way. Bell's law says that every 10 years, a system turns over and a new system comes into place. So during that time, who's ever managing the system has a lot of influence. But once we move on from like what we had with the Nokia type phones that were giving us sort of like our broadband access on mobile to the iPhone, Android world, that was a complete change in what the system was going to look like. Mm-hmm. And that's the kinds of things that we should be thinking about and dealing with. And our current techniques for antitrust don't deal with these very well. What I think we need to do is kind of go back to our roots, things that were talked about 200 years ago, which is, where does market power really come from? Right now, we have kind of an ex post view. We say, oh, there it is, but it's elusive now. So what we want to know is, where does it come from? And try to deal with those source issues, as opposed to, I found it and oops, it just slipped out of my hands.
No, this is really interesting. Well, I want to unpack some of those different issues that you raised a little bit further. So we'll spend a little time kind of talking about some of these current issues and challenges that big tech poses in these markets. And then we'll move in spending the rest of our time discussing some possible solutions, particularly some of those that were proposed and raised by the senators in their remarks this morning. So I want to just circle back to something that you said, Dr. Jameson, about the issue of these private ecosystems. Professor Newman, I know this is something that you wrote on in your Vanderbilt Law Review article as well. And so, this is open to all of you to talk about, but wanted to just ask, what is the kind of private ecosystem issue in terms of these companies kind of acquiring other firms that aren't necessarily direct competitors in their markets, but allow them to create these private ecosystems, and then that kind of becoming a harm to consumers and harming competition. So if either of you would like, any of you would like to speak to that, I would be curious, just to hear about how those private ecosystems are presenting challenges in the antitrust space.
Well, I can take a brief crack at it, at least since I've written a little on this topic. It is a thorny one, I would say. I think I called it at one point, the sort of Google antitrust paradox. That is, when a company like Google builds out what we're calling an ecosystem, right? They don't just offer search, a kind of core product where they started, but now search is sort of tied into maps and flights and Gmail and YouTube, et cetera, in a way that makes it very easy for a user like you or I to navigate among those arguably different products, right? All of this is, by the way, challenging what we even, are referring to when we use words like product. But anyway, so what happens when Google acquires a company like, Waze, right? And then builds out Google Maps is that it makes it easier to stay within that ecosystem, but it does, reduce some form of competition at the same time. I think it's oftentimes in cases like that one, or YouTube would be another example, it can be kind of hard to prove a user harm, right? Because, part of what we're saying here is the ecosystem is powerful because it's easy for users to navigate within it. So there's a kind of arguable consumer benefit right off the bat. It's a little harder to see in some of these cases the consumer harm, at least in sort of traditional dollars and cents terms. I think you can point to things like a loss of choice. That's a slipperier concept. I don't think we've defined that quite as well in the antitrust community. So I think, when we start talking about ecosystem markets, I guess hearkening back to my first set of comments here, it does get a little, it does force the issue. It does force us to ask, what are we really trying to do here with antitrust? Are we just trying to, make the world a kind of seamless consumer experience, and we don't really care if one company does all of that as long as there's consumer benefits that are quantifiable? Or are we trying to preserve some kind of democratic, I guess, dispersal of power across the market landscape? And I just think there are questions like that we haven't really wrestled with firmly in recent years. And I think events like this one are evidence that we are starting to do that again.
That's helpful. Yeah, Senator Hawley kind of recognized this a bit in his remarks this morning, just that, there's a danger of, I guess he used the term cross-subsidizing these businesses and kind of pushing out competitors in multiple markets. And so it sounds like, this is something that antitrust law might need to grapple with more. And kind of on that note, it's been raised, by many of you, just the issue of kind of who is the constituency, like who's being harmed, how do we measure that? So I guess this is a kind of big question, but do you think that the consumer welfare standard, the kind of current antitrust approach, is up to handling these kind of big tech issues with antitrust? And how do we then measure harms to consumers? Is the consumer welfare standard kind of enough to protect and promote competition in these markets? Anyone who wants to jump in on that.
To that issue, that's a very complicated question, and this is an area of intense debate. I think that there is an appetite from our friends on the left to try to rethink the consumer welfare standard and suggest that maybe we should go to a broader approach, such as perhaps a public interest standard. I think among Republican and conservatives generally, there is a very strong desire to maintain the consumer welfare standard. And then the only question is, how do you define the consumer welfare standard when you have not only price concerns, but also quality concerns or other sorts of concerns that are not easily captured by traditional economic measurements? And so we have a situation, I think, in these markets where there are both price concerns and quality concerns that are part of the consumer welfare standard. And so I think, for example, privacy could well be part of the consumer welfare standard. It's simply a quality experience that consumers care about. And there's no reason to say that the consumer welfare standard is incapable of addressing privacy concerns. You simply have to frame it from the perspective of not only price, but also quality. The difficulty is when you're trying to balance pro-competitive and anti-competitive measurements, and they're incommensurate, right? Economists really struggle. They very openly struggle with how to measure the harm to quality from something like privacy, which obviously each individual consumer has a slightly different view about protecting privacy. And then how do you counterbalance that with economic analysis of pricing behavior? So I think I would generally say that the courts and most experts on the right are going to continue to maintain a consumer welfare standard. But it is definitely up for debate about whether or not there should be a broader standard.
Mm-hmm. No, that's helpful. And yeah, go ahead, Dr. Jameson.
Yeah, if I could just add to it, I think Roger's exactly right, that there is a vigorous debate over what's really our standard here. Is the economy really about consumers, or is it about dividing up the economic rents among whoever is filing court cases? And he's right that there's a lot of people more on the left side of things that would really like to do away with the kind of rigorous analyses that we've had before and just kind of have some rules of thumb, if you will, that if a company is really successful, there's got to be something bad going on. So let's try to deal with the company. Mm-hmm. You mentioned earlier about the cross-subsidization going on. And I don't think antitrust has dealt very well with ideas of cross-subsidization. we tend to be very loose with that kind of language. We're very loose with words like privacy. My colleague at the American Enterprise Institute, Jim Harper, has written a whole book about this. That it's just this potpourri of ideas. And that's why Roger's exactly right. It's really hard to measure because everybody means something different by it.
Mm-hmm.
So I think we want to think very carefully about when we're talking about something like a cross subsidy is going on. We want to be rigorous in what we're talking about. The economic definition to date is that a cross subsidy is happening if someone is part of an ecosystem or an economy, and everybody else would be better off if this person just wasn't even around. Then that person is being subsidized. And if we stick with that standard, then we can deal with that issue pretty easily. If we allow it to just mean things I don't like, then we'll continue to struggle.
Well, can I speak to the cross-subsidization issue? Because this is, I think, a really interesting and important issue. So traditionally, courts and economists are skeptical about predatory pricing because there is a sense that low pricing behavior for a significant period of time is unlikely to be harmful to consumers unless there is evidence that low pricing behavior drives out competition, and then there's a recoupment that happens through higher pricing after they've successfully driven out competition. That's the classic model of concerns about predatory pricing. When you have a monopoly across different segments of a market, it is quite possible to arbitrage your pricing behavior. And so that where there is competition, you have very low price behavior, and then where there is almost no competition, you increase your prices, and you can arbitrage your pricing behavior across segments contemporaneously. You don't need to wait for a future date to seek recoupment. You essentially can recoup your low pricing where there's competition elsewhere. So for example, you can have very, very high prices on search advertising and lower prices on display advertising if there's competition, or you can have very, very low prices, almost commodity pricing in one segment of the stack, and then very high prices where there's almost no competition in another segment of the stack. So I think that's an example of recoupment that's different than the traditional metric that we have for predatory pricing.
That's helpful.
If I could just add, and that's an illustration of where we need to be very careful about what we mean by cross-subsidization. Because if I'm that monopolist and I've got a monopoly in this market, I don't in this market, if I can charge a monopoly price over here, I can do it whether I'm trying to deal with competitors over on this more competitive market or not. And so I'm not necessarily driving a cross-subsidy. I am, just as the predatory pricing literature tends to say, losing money in this other market with the hopes of getting it back someday, because my trying to drive out competitors over in this other market doesn't really affect my profitability in the market where I'm charging a monopoly price. I can do that anyway. And so we just want to tease those concepts apart and make sure we think about them carefully.
No, that's helpful. Just circling back a little bit to the consumer welfare standard and some of the issues right now in antitrust, how can we measure harms to consumers in these digital attention markets? If these are, zero price markets and price has been the traditional measure of harm to consumers, what other measures are available? Can we be creative in thinking about other types of harms? How would we kind of quantify those in terms of these attention digital markets?
Well, I think for starters, I guess, again, we'd have to think about which sort of group of people we're trying to assess harms to. If it's advertisers, of course, we could look at traditional price harms. We could also look for things like lower quality, et cetera. But you could, treat that side or downstream or whatever part of a market as a fairly traditional one, I think.
Mm-hmm.
When it comes to zero price side, things get a little trickier. I guess my preferred sort of metric would be looking for a sort of traditional like overcharge, a monopoly overcharge, but just in the form of attention costs rather than in the form of money. So if you could say, demonstrate that before a merger, you had two firms competing head to head. Let's say it's two companies that are kind of like Facebook and Instagram, but not exactly those two. So it's a hypothetical. And before the merger, you see advertising load set at a certain level for users. It's going to vary user to user, but let's say post-merger, you see overall advertising loads go up, and you find some internal documents, communications that suggest, yeah, once this merger happens and we don't have the competitive constraint of that other company, we'll be able to jam more ads down people's eyeballs. That to me seems like a pretty traditional antitrust case in theory of harm. You know, it might be a little trickier to quantify, but I think you could do it, right? If you had a good econometrician.
That's helpful. I want to kind of keep moving because I know our time is limited. So kind of getting towards solutions, you know, Professor Newman, I know you've written that it seems that the current kind of antitrust approach to digital markets has been very kind of pro-defendant and hands-off. And you argue for a kind of more interventionist approach. And so just a question for kind of all of you, you know, what do you think needs to be done in terms of, you know, before we get to kind of some legislative solutions, which I do want to talk about Senator Lee's and Senator Hawley's legislative solutions, as well as the House Judiciary bills with Congressman Ken Buck and other co-sponsors. But I want to first ask, before we get to legislation, what do you all think could be done better in terms of antitrust enforcement? You know, the way our laws are today as it comes to these digital markets. You know, is a more interventionist approach needed, and what would it take to increase that enforcement?
I can speak to that issue, putting aside for the moment legislative proposals. I think that there should be more vigorous enforcement. I think there should be more funding available. The budgets for the FTC and the DOJ were flat for several years, even decades, and they were not even adjusted to the CPI. So you could definitely say that budget increases for more vigorous enforcement for the DOJ, for the FTC, for the state AGs, all of those things would be welcome, I think, and helpful. State AGs, there's very few states that actually have large antitrust departments. Most of them have one or two antitrust lawyers, and no economists. And so more significant funding by state legislatures or perhaps by the federal government for state AGs would be welcome. I also think that the attitude of enforcers should be slightly different. I think there's a general sense of we should only bring cases that we're quite confident that we're going to win. Whereas I think the attitude should be we should take cases that have genuine concerns about the competitive markets, but we know that it might be difficult to succeed on those. So there should be, I think, a change in mindset that we should not view losing a case as a failure, but rather we should view the need to bring more cases as a point of trying to tell the market that we're very concerned. I also think on mergers that there is an increased interest in more vigorous enforcement on mergers. I can think of, for example, nascent competition. Everyone talks about Instagram as the example of it was quite clear that it was purchased right before they became a full-blown competitor so that they could get through the merger process. And that's an example, I think, of nascent competition being, perhaps in need of more vigorous enforcement. So I would say the most obvious solution is more enforcement powers and also more vigorous enforcement by the federal and state AGs.
No, that's really helpful. Anyone else?
I would say if I could offer just one thought, again, this is like all of these, a really rich question, but maybe just one thought is, I think to some extent, regulators back themselves into a corner over time by endorsing, particularly in the horizontal merger guidelines that they issued jointly, the US FTC and DOJ, Antitrust Division, by endorsing increasingly kind of hyper-technical approaches to legal questions like how do you define a market, right? And this gets back a little bit to some of the things that Dr. Jameson was discussing earlier. In these contexts, those hyper-rigid, hyper-technical approaches like trying to ask what a hypothetical monopolist would do in a hypothetical world to a hypothetical price that doesn't even exist, because we're in a zero price context, for instance, just makes very little sense. Now, those guidelines sort of started to bleed over into all types of antitrust cases pretty much. And so I think part of regulators' job now is to sort of educate courts on when those approaches might make sense and when they don't. And I think you're seeing things like this FTC v. Facebook case kind of running into that question of market definition and running aground a little bit. So I think it's going to take regulators themselves endorsing more flexible approaches, not suggesting to abandon economics or anything like that, but to explain to courts when and why more qualitative factors might be important, when a more flexible approach to market analysis might be necessary if we're going to even have antitrust at all.
No, that's really helpful.
I can chime in.
Go ahead. No, go ahead, Dr.
Please?
Jameson.
Yeah, just to talk about that a little bit. The problem with stepping away from actually analyzing markets is that then we fall into folklore, which we see a lot of going on today in antitrust. People just know that there's market power. They just know that these companies are bad. They just know. And so you go right back to what Brandeis did when he was doing antitrust. He just picked out people he didn't like and went after them. It was very personal. And that is the way that things will go if we don't have some sort of rigorous analysis, rigorous standards. And relating that to the current case for Facebook that just got kicked back to the Federal Trade Commission and some of the state attorneys general, that the problem there was that they really did pick a bad market to try and analyze. They said that they were going to pick personal social media and claim that there's a 60% market share, and by golly, that looks a lot like market power to us. And the judge says, I'm not convinced. And the judge was quite correct in that. Because if you look at people's actual use of social media, Facebook occupies about 8% of people's personal social media time. That doesn't sound like a large market share. It certainly doesn't sound like market power. And it's important to understand that time and attention market is actually an input market. It's not a product market. It's an input for the advertising. And so you want to start looking then at the advertising market. That's where I think they should have been looking and saying, is there market power there? And if there is, then we can maybe say something about how the inputs are acquired, et cetera, rather than try to talk about whether people had enough options for social media, which clearly according to the behavior, they have quite a few.
No, this is all really helpful. I would love to start moving into kind of some of the legislative solutions that we have heard proposed by the Congress members, and just starting off with Senator Lee's TEAM Act, which really seeks to kind of codify and update the consumer welfare standard. Wanted to ask, what you all think of his approach in particular in terms of trying to really codify the consumer welfare standard. And I guess a question I would also ask is, how then does codifying that standard, what does that mean in terms of competition in these markets? How is competition considered then, as a factor? Is it only in the sense that the lack of competition affects consumers and drives up price, or is codifying the consumer welfare standard going to limit how we look at competition as well as a factor in these markets? So that is my kind of first question, just around Senator Lee's TEAM Act, and any other thoughts that you might have on that approach.
I think that consumer welfare standard is very well established in the jurisprudence of the courts. As we haven't really said this explicitly, but it's very clear that the antitrust law, the common law approach, that is grafted onto a very vague statutory requirements. And so I think that legislation is simply trying to crystallize what is already the existing law. Mm-hmm. So to that extent, it doesn't really change the status quo at all. I think what it might do is try to anticipate efforts to modify the consumer welfare standard through the courts. And so I think that if it were to pass, it would simply, I think, maintain the status quo with respect to consumer welfare standard. That's my impression.
Mhm.
I'm curious, if John or Mark have different views about that.
One part of it that really piqued my attention or my interest, and that I strongly agree with, that Senator Lee mentioned this morning, was the idea of requiring defendants in antitrust cases, and here I think we're talking about rule of reason cases, not garden variety price fixing cartels, to actually quantify and actually offer actual evidence, real world evidence of their claimed efficiencies. Right. So the way that most antitrust litigation works these days is the plaintiff bears the initial burden, and they have to come forward with actual evidence that tends to prove that the conduct at issue was harmful. And then the burden shifts to the defendant. And recently, although you can trace this back a little ways, but most recently in the Supreme Court's 2018 Ohio v. American Express decision, a majority of the court suggested a defendant can carry its burden not with actual proof, but by just asserting efficiencies, basically just saying there's some nice explanation out there that might make sense of our conduct. And that's, I think, wrong-headed for all kinds of reasons. So the idea that this TEAM Act would require defendants, instead of just saying something like, ooh, free riding, to require them to actually come forward with some evidence. They're in the best position to do that since it's their conduct that's at issue. I think that makes a lot of good sense to me. And I think other parts of the act, abolishing the FTC, I disagree with pretty vigorously, but that one in particular strikes me as very right and justified.
That's helpful. Yeah, and I think other parts of the TEAM Act, I didn't mention this in my initial question, but just we're trying to really clarify some of the types of evidence that are required or at issue in these antitrust cases. And I know another part of it would require that courts do find conduct anti-competitive if there is direct evidence. And so I don't know if either of you or any of you want to speak to that kind of standard that the act tries to impose. If there is direct evidence that a merger acquisition was taken as to clearly limit competition, like the CEO of this company said it in their own words, and we have that email, that the court would need to then find that conduct is anti-competitive. Do any of you have thoughts on kind of that new standard that the act would create in terms of that type of evidence?
I can chime in first on this one. So I apologize, I've not read that specific bill. I'm a little skeptical of gathering CEOs and et cetera's emails and memos and such, and using those as evidence. I've worked in a corporation before. There's a lot of hubris in corporations. There's a lot of arguments that in a context people are trying to make to sound persuasive. They say all kinds of things. One of my favorite characterizations of our corporate strategy people is they were the only people I'd ever met that sitting in a chair, they're still swaggering and strutting. It's just, that's kind of the culture that you have. So I take a lot of the things that are said with a grain of salt. I really would, as John and Roger were talking about earlier, like to require some real evidence that there's some harm. Now, it is hard to do because we're talking about counterfactuals. Mm-hmm. And as we saw in the AT&T Time Warner, Carl Shapiro is a brilliant economist. He did a great job of trying to say there could be real problems here. And he's right, there could have been real problems there. But clearly, even AT&T and Time Warner did not realize how difficult it was going to be to even have a successful company, let alone one with market power.
No, that's helpful. I want to touch on a couple of the House bills. So I don't know how much you've been following that. There were 6 different antitrust bills that passed out of the House Judiciary Committee last week. And we heard from Congressman Buck this morning, who's a co-sponsor of those particular bills. And just, if you've followed along, if you have, first of all, if you have any general thoughts on some of these bills, but also I just wanted to kind of highlight a lot of them seem to be focusing on trying to prohibit dominant firms from giving their own products or services advantages over competitors or disadvantaging the products of others on their platform. And, Senator Lee's TEAM Act also does this, trying to prohibit basically discrimination in these kind of distribution markets that someone with a monopoly in a distribution market that also offers a product or service that competes in that market can't engage in discrimination against other competitors or that might be competing with their product. And so, I know that we kind of touched on some of these harms earlier, but do you all have thoughts on those bills' approaches in trying to prevent that type of kind of discrimination and preferencing of their own products, disadvantaging others, and if these bills are going to correctly kind of address some of those concerns?
Well, it's important to emphasize that those bills are limited very, very narrowly to the largest of the big tech companies. So it doesn't cover the vast, vast majority of companies that might engage in sort of discriminatory practices. And I think it's a recognition. The reason I think they do that is because they recognize that the power of those companies are of greater concern than the typical competitor. So in that context, I think the price discrimination concerns are legitimate. Or other sorts of discriminatory practices are legitimate, that there is in fact this ability that they have to bring everyone to their platform and then to act in a way that discriminates against other actors on their platform and then use the data to advantage themselves. And so I would suspect that the discriminatory practices that are concerned in those House bills could get some real traction. It's very similar to the French authorities' settlement with Google earlier this month. If you look at what the settlement was about, it essentially is concerns about discriminatory practices in which Google always self-preferences within the ad tech stack. So I think that particular legislation could get traction because it's targeted to the largest companies.
That's helpful.
I think too, if I could add just a word on that it's important to remember, and I feel like it sometimes gets lost in the Twitter debates that happen on these things, that that particular piece of legislation also does include an opportunity for these companies to come forward with good explanations for their discrimination, right? It's not a hard and fast ban of all self-preferencing. So you're not going to see, iPhones come with no apps anymore. They're not going to be just little bricks that you get at the Apple store. So, I think some of the sky is falling mentality that you see among certain commentators is probably unjustified. I think there's still a chance for companies to, if they're doing these things for good reasons, to explain why.
And I think that's a fair point, that there can be very good reasons for just looking like you're discriminating against your rivals, and probably actually are. So we want to think about that carefully. I'm concerned about some of the things I've seen out of Europe for several years in this regard. So for example, let's take Google, for example. It does self-preference. It's my understanding is, I've not actually examined the evidence. My understanding is it does self-preference some of its businesses that it provides, hotels, airlines, etc. If the profitability of doing that incentivizes Google to drive more customers to its search engine, that actually can be very good for the customers, because then it really wants to make that search engine good. It has to make that search engine even better to actually get the customers there, which may or may not help the rivals, but certainly does end up helping the customer. So that's the kind of thing you want to analyze. Not all discrimination is bad. It actually can be quite beneficial in the end.
No, that's helpful. I want to ask you briefly about kind of some legislative approaches around mergers and acquisitions. So Senator Hawley's bill really tries to basically place a cap that if you're over 100 billion as a company, then you're banned from any type of merger, and also seeks to kind of break up some different lines of businesses that these companies may have already acquired. And I think in general, it seems that his approach is moving away a little bit from the traditional consumer welfare standard. It seems to be, he's reached a point of basically saying big is just bad. And, even if that means that consumers may have benefits from some of these mergers, that at a certain point you're just too big and it's harmful. And so we talked a lot about the economics, and I'm wondering, is there ever, in any of your minds, a place in antitrust law where at a certain point we say it's not just economics. There might be legitimate political concerns for our country, for our democracy, for our society, where companies have just gotten too big and have too much power and control over our society, whether or not you can prove all the kind of economic harms to consumers. So that's a bigger philosophical question, but then also specifically, wanted to hear what you would think then of Senator Hawley's bill, really trying to break these businesses up, prevent any kind of acquisitions for companies over 100 billion. What you think of his approach?
With respect to prohibitions on acquisitions, I think rather than using a market cap number, I think it's better to use a market share number. I think that market cap numbers have the potential to be arbitrary. For example, Amazon acquisition of Whole Foods could very arguably be pro-competitive because prior to that, there was not a robust, effective distribution mechanism for food delivery, right? And so you could say that Amazon's ability to deliver and leverage its distribution channels in the food market could actually be pro-competitive, and they're in clearly separate markets. That's an example where I don't think this pure market cap makes the most sense. I think the other option is once you have a certain I think this is a Klobuchar bill. Once you have a certain market share, then there may be limitations that should be imposed on your ability to acquire either nascent or actual competitors. That to me comes closer to what is the heart of the concern.
That's interesting. Anyone else have any?
Just without weighing in on whether that particular proposal is good or not, I guess I would say, and I think the traditional concern here, of course, is that if we prevent these tie-ups, that we'll lose out on all these wonderful efficiencies that come from combining companies, right? For some time in antitrust history, the general thought was that big is bad. For another period of time in antitrust history, the general thought among a lot of people is that big is good, right? That's a gross overgeneralization, of course. But if you look at, speaking of the economics, if you look at the actual industrial organization, even more the management strategic literature that's out there, it really doesn't back up that story that mergers generally yield efficiencies, right? People have looked hard for mergers that actually yield efficiencies across various sectors. And the general consensus seems to be that mergers on average, again, generally speaking here, don't yield recognizable efficiencies. They often yield a bonus for the target firm's shareholders, but that's about it. And we've seen a lot of these high profile mergers that just kind of fall apart, they fail. What causes these mergers? Maybe getting back to Dr. Jameson's suggestion that there's a lot of hubris that floats around these companies. That could be an explanation here. I'd just suggest that whether or not that particular proposal is a good one or not, and I'd have some concerns about it, the downside risk is probably not as big as some people would have us believe.
No, that's helpful. And do
Can
any?
I chime
Oh,
in
go
on
ahead.
it,
No,
please?
Dr. Jameson, please.
Sure. So the idea that we should take down the size of firms because they may control the country, it's not new. Actually, that was one of the drivers between how Judge Harold Green thought about the AT&T breakup. And I'm skeptical that is actually a good application of antitrust. Clearly, the content companies, the social media companies can influence dialogue, and they certainly believe they can influence dialogue in the country. We can see that in the actions that they take. That, I think, is a separate issue from antitrust. That we want to take care of. Section 230 may be a place to take care of it. Thinking in some dimensions of common carrier may be a place to take care of it. I'm skeptical of using antitrust for it. And as John was implying, mergers and acquisitions happen for a lot of reasons. He's right that it's pretty rare for shareholders to benefit from these. Management tends to benefit, but shareholders tend to not so much. So I don't worry a lot about mergers and acquisitions. And one of the things to keep in mind, I think, with respect to those, especially in the tech industry, is a lot of time what you're buying, if you're buying another company, is the people. You're not necessarily buying a product. There's a case, and I've forgotten this name. I recently read the history of artificial intelligence, and there was a few professors put together an AI firm. They thought about going to the big tech companies and saying, here's our idea. Couldn't get much of an audience, didn't really want to work for a big tech company. So they formed their own firm, fairly little. It lasted for about a year, became worth a few $billions, and was bought by one of the tech firms. I don't remember which one. But that's how that particular idea got into how we do artificial intelligence. It had to be through somebody starting up a firm and saying, look, I demonstrated this idea has some value. Nobody else can figure this out as well as we can because this is our academic research. And then that becomes a new addition to how we do AI in this country. So the mergers and acquisitions can be quite diverse. And I think it's problematic to have kind of a broad brush and say they're all going to be bad over some particular threshold.
Claire, can I speak to the political power issue? I do think that the one thing that clearly does unite Democrats and Republicans on these big tech companies' power is that they can exercise their power not only in the market but also in the political sphere as well. And there are examples of that that alarm those on the left, and there's examples of that alarm those on the right. Examples, things like Cambridge Analytica, things like Parler taking down not only an individual user, but an entire alternative platform. All of those kinds of concerns do in fact evidence the overwhelming political power. And there's even some suggestions that I think are quite plausible that that certain companies can influence public opinion in the way that they raise or lower the dial with respect to advertisements, political advertisements, and that can actually have a measurable impact on the voting behavior of individuals. There's actually literature and research on that. And all of those sorts of things, I think, should be cause for concern. And exactly how we deal with that, as Mark is suggesting, is very complicated. It's not clear that political power translates into the traditional understandings of concerns about consumer welfare. But that doesn't mean that there should not be genuine concern about that kind of political power.
That's very helpful. And then we are running up on time. So I want to ask my last question very briefly. But you were just kind of segueing into it, Professor Alford. So I did want to just ask, I think antitrust seems to be an area of more bipartisan agreement, that there's actually concerns by both the left and the right when it comes to some of the issues with antitrust. And so I just wanted to ask, in terms of that bipartisan consensus, do you think that there are areas of real agreement, or should conservatives be wary of some of the kind of approaches being put forward by the left? And one thing I just wanted to specifically highlight is I think there's been a debate between empowering the FTC versus empowering the DOJ. And I know that the House antitrust bills kind of empower the FTC. Senator Lee's TEAM Act would put all antitrust enforcement under the Department of Justice. Because I think some conservatives are concerned that the left would grow kind of the government's power with the FTC through rulemaking, trying to rule-make on antitrust issues, and also that there can be a little bit more of a lack of political accountability between administrations. The FTC is a little bit more insulated in that way. So I know we don't have a lot of time, but if anyone would briefly, if you have any thoughts on kind of areas of bipartisan consensus, but also areas that could be seemingly bipartisan, where we as conservatives might want to be a little bit more cautious, and particularly maybe even in the area of that FTC or DOJ debate in terms of enforcement powers.
I mean, I think that there's no doubt that there is an unusual amount of bipartisan consensus that these companies have too much power in the marketplace, and that there should be vigorous enforcement to address their most egregious types of conduct. If you look at the state AG litigations, every single state in the country, I think with the exception of Alabama, has joined at least one of the various suits against big tech. If you look at the New York Facebook case, the Colorado Nebraska case, the Texas Google case, every single state has joined at least one of those cases. And that, I think, speaks to the level of concern. I do think that some of the arguments on the left are not going to be accepted by those on the right. I think the elimination of the consumer welfare standard is the most obvious example. But others, I think, on the legislative front very well could be accepted. Shifting the burden of proof on mergers or limiting nascent competition mergers, those kinds of things very well could be accepted, I think, by both sides. I think the one great unifying factor, though, is we need to be bringing more cases to address these concerns, and we need to send a clear signal to some of these companies that the business as usual is not going to be allowed, that there actually are genuine concerns about some of their practices.
Does anyone else have a last word on this, and then we'll conclude?
Maybe a last word or two, I guess. You know, it's stepping back for a minute, even from that, this is a big question, but you know, stepping back, I think it's worth remembering that antitrust itself has always been, in a sense, a kind of compromise between the left and the right. Antitrust was a kind of a middle road, as between, you know, sort of a true socialism, national ownership of various industries, or heavy regulatory management to include, you know, price regulation. That would be the kind of left position, and on the right, a kind of ultra laissez-faire, you know, companies can do no wrong approach. You know, I'm actually not that surprised to see some bipartisan consensus emerge in the way that it kind of did back in the 40s and 50s. You know, we had just gone through a period in which just letting the market do whatever it wanted didn't seem to work very well. On the other hand, in the early to mid 30s, we tried a heavy regulatory overlay in a bunch of industries, and that didn't seem to work very well. And then you saw this kind of period of more or less bipartisan consensus around a strong antitrust approach to include both agencies, right? The FTC with its unique ability to really gather facts about entire industries, rulemaking if necessary, and the DOJ, a real law enforcement agency. You know, so I guess I would say that this is, to me, a kind of a return to a historical moment that is not so unusual. And I don't think there's a lot of, you know, need to be overly concerned about what's happening for those on the right.
No, that's really helpful.
I would just add, maybe I'm just repeating, but there is a lot of political will to attack the big tech companies. There's no doubt about that. That's on both sides. I'm skeptical that either side would improve our laws beyond what they are. I do think the practitioners have a lot of work to do, because the way things work today within these industries are different than what we've experienced before.
That's really helpful. I'm so sorry we're at time, but fascinating conversation. Thank you all so much for your time and for sharing your expertise and research in this area with us today. And with that, we'll conclude this panel, and we'll take a brief 2-minute break before resuming our third and final panel on common carrier. So thank you all so much for the conversation. Appreciate it.
Thank you.